Hello, everyone. You're all very welcome to this evening's webinar. My name is Michael, and I work in AsIAm, and I'm delighted to be joined by Information Commissioner Ger Deering. Tonight's webinar is a very important webinar. It fundamentally looks at key issues around rights and transparency and access to key information relevant to yourself or indeed your child. And I suppose at the heart of it, it's about you guys leaving tonight's webinar with a little bit of information in navigating that system around freedom of information or freedom of information requests. You might have heard the recording prompt there that this event is recorded and will be available on our YouTube channel in the coming days. And also we have a Q&A session at the end of the webinar, so we won't record the Q&A session, but we certainly will record the webinar itself, and that will be circulated via email and also on our YouTube channels. So as I said from the outset, I'm delighted to be joined by Ger Deering, who is the Information Commissioner, who also wears a number of hats. He's also the Ombudsman as well. And Ger is going to speak on a number of key topics. The presentation should last maybe 25 to 30 minutes. And then, as I said, there's opportunity for people to put questions in the Q&A box, and I'll monitor those as they come in, and I'll put some of those questions to Ger at the end of the presentation. So the presentation itself will cover the role of the Information Commissioner, how to engage with a Freedom of Information request, appealing a Freedom of Information request, and the law surrounding a Freedom of Information request, and some of the bodies and agencies that are subject to a Freedom of Information request. So a very practical webinar and very practical information for you guys to take this information and to use it should the need arise in the course of your life. So I'm going to hand over to Ger, who's going to present, and as I said, for about 25 to 30 minutes. And do please include your Q&As, your questions in the Q&A box, and I'll put them to Ger at the end of the presentation. So Ger, I'm going to hand over to yourself, if that's okay.
Thanks very much, Michael, and thanks to you and Adam and indeed all the team in AsIAm for the opportunity to be here. Delighted to have this opportunity to talk to you and the people online this evening from your organisation about FOI, that what we consider to be a very important concept, and so the Act goes back actually as far as 1997, and it came into force in April 1998. And sometimes people may not realise that it actually replaced, well, it didn't fully replace, but prior to that, all we really had was the Official Secrets Act. And unfortunately, I'm old enough to have worked in the public service at the time when the Act came in. And it was absolutely a sea change in how people working in the public service looked at their work, and maybe in terms of how they dealt with the public, because up to that, there was a kind of almost a view that why is this anybody's business? Like, it's our information, as in those of us working in the system, which of course is not the case. And very often with legislation, you can get a good sense from the long title of the Act as to what that Act is. And you can see there on the slide that it's described as an Act to enable members of the public to obtain access to the greatest extent possible, consistent with the public interest and the right to privacy, to information in the possession of public bodies. So that's also the Act that established the Office of the Information Commissioner, the office that I head up currently. It was updated with the Freedom of Information Act 2014, but I'm not going to go into too much of the legislation. I'm going to talk more this evening about the practicalities. And as you've already mentioned, the legislation sets out that the Ombudsman is actually the Information Commissioner. So whoever holds the post of Ombudsman at the particular time is also the Information Commissioner. So if you could move on to the next slide, please, Michael. Thank you very much. So the objectives of the FOI Act are set out there, and it really is about improving government. Two things. There's two different threads to FOI. One is getting information about the public service and about what's happening and all of that. But equally importantly is it helps people to get information about themselves. And in some respects, it predates some of the data access legislation that subsequently came in. So when it came in first, it was innovative in that regard, in helping people to get access to their own information. But it's also about transparency in government, so that we can understand why particular decisions are made and the thinking behind them. It is meant to discourage corruption. And I think in many respects, it has done that, because people, again, can look at motivations and see why people did certain things. And it's about holding the government to account and informing the government about government and its decisions. And all of that really is designed to improve how decisions are made. If we're all accountable for our decisions, and if we all have to explain and have the decisions and the background to them publicly available, that should improve the decisions that we arrive at. And it also acts as a check on exercise of power by government and agencies. So people, they have to account and explain for their actions because this information is made available to people under FOI. Of course, we constantly say to public bodies, put the information out, other than personal information, of course, of an individual. We encourage public bodies to put as much information as they possibly can out in the public without having to be asked under an FOI. But I'll come back to that in a little while. And it's also designed to promote citizen participation. So if you don't know what's happening and if you don't know why decisions are being made, it's hard to comment and to communicate with government as to what your thinking is and what they should do. So it assists in that as well. And we'll move on, please, to the next slide, Michael. So the purpose of the Act is it really sets out three rights. One is, I mentioned already, access to records that are held by FOI bodies, and that can be about any topic or any subject. But also it is about whatever that government department or that body holds on you, if they have personal information belong to you. And importantly as well, it allows you to ask or request that information be amended or deleted if the information isn't correct. And if the body doesn't have a good reason to hold the information, you can actually ask that information would actually be either amended or deleted. And it also, while it is about getting records, and I'll talk in a minute about the fact that public bodies aren't necessarily required to create records, it does also provide that you can get a statement of reasons for an act or a decision that has been made by a public body that actually affects you. And our role is to review decisions of the FOI bodies. I'm going to go in a minute and talk about how you approach an FOI body and how you would seek to get the information. And then I'll talk about how you can come to our office if you're not satisfied with the decision of that public body. And it's just maybe to point out as well that FOI and GDPR, the Data Protection Regulation, they provide different rights of access. And we're responsible only for the right of access that's available under FOI. The Data Protection Commission is responsible for GDPR. That can cause a little bit of confusion for people sometimes, but they are two separate regimes with different legislation and different access routes. So we'll have the next slide, please, Michael. There's a whole range of FOI bodies. I mean, the vast majority of public bodies are actually covered by FOI. So all government departments, and if you think about it, that is a very broad range of bodies, all local authorities, the HSE, which I think probably always tops the list of bodies in terms of the numbers of FOI requests made to public bodies, and it is mainly people looking for personal information. It also covers TUSLA, public hospitals, universities, education and training boards, and a whole range of bodies like the Housing Agency Legal Aid Board and that. Now, some bodies, public bodies, are only partly included, and we've given the example there of the Gardaí. So you can seek FOI information under FOI about the administration of the Gardaí or their accounts or how they purchase things, but not on the substantive role of the Gardaí. So in other words, you won't get a file relating to a particular investigation or a file in relation to a particular activity of the Gardaí. That is protected for security purposes. So there are some bodies in that fall into that kind of category where you can get the information about their administration, but not necessarily about their particular activity. So next slide, please, Michael. So I think probably this is the important bit for most people in terms of how to make an FOI request. So I suppose the first thing is to know or try and find out that the body is covered by the FOI Act, but it probably is. If it's a public body that falls into the categories I mentioned earlier, then it is most likely that they are subject to the FOI legislation. When you make your application, they have 4 weeks to make a decision. on your application. And it's important to actually allow that 4 weeks. Sometimes people come to us maybe 3 weeks in or 2 weeks in and say they want to appeal because they're not getting the information. But the law provides that the public body has 4 weeks, and it prohibits us from actually dealing with an appeal before that 4 weeks are up. So you must actually give the body the opportunity. And indeed, if you're refused, you must actually go back and request an internal review. Sorry, you don't have to, but before you can come to us, you have to request the body to do an internal review of your request. And so the body has 4 weeks to do to respond to your request. You have 4 weeks to consider whether or not to do an internal review. If you ask for an internal review, that takes the public body has 3 weeks in which to conduct and complete that, and then you have 6 months in which you can appeal to us. Now there are certain situations where it's 2 weeks, but it really doesn't. We're talking about the 2 months. Those 2 weeks apply to certain bodies who might be affected by a decision, but for the requester, you have 6 months to appeal to our office a decision of an FOI body. We'll go on to the next slide, please, Michael. So, in terms of how you must make a request, so you have to make it in writing, first of all. Try and identify the body, obviously, that you believe has the request. You provide identification when requesting the personal information, and try and make your request as specific as possible. Sometimes people make very general requests, and sometimes this is done thinking, well, if I tell the body what I want, for some reason, I might not get it, but that would be completely unacceptable. And to be fair, what we see in public bodies is that in the main, they do actually comply to the law. There are times when they might say they don't want to release a record, but we have no evidence ever of a public body hiding a record or deliberately destroying a record. We're not familiar. We've never seen that happen. So the point I would make is, if there's a very specific document you want, ask for that document. It will assist the public body to find the document, and it will also speed up the process in our view. Sometimes people make, as I say, and sometimes journalists make kind of very broad, what we call phishing requests to see might they find anything in there. It's acceptable, like it's legal to do that, but it may not be the best way of getting the information. The best way to get the information is to actually specify what it is you want, particularly if you know that a particular record does exist, and to refine it maybe to a period of time. If you're looking for something that happened last year, then try to refine it to the period when you think it might have happened, rather than saying I want all of the records over the last 10 years if the other 9 years are really of no value to you. You're really only maybe delaying the process and putting unnecessary burden on the public body. Medical card holders can access their GP records, but from the HSE. So this is kind of an unusual one. So individual doctors, they're sole traders, they're not public bodies, but they do hold the records on behalf of the HSE. So in that instance, they can be retrieved in some instances from the HSE. Now, this is the point I was making earlier, that FOI bodies, they're generally not required to answer questions or to create a record. It's about access to records that exist. So sometimes people say, they'll request a particular piece of information, and it's deliberate that the word records is used in the Act, not information. So if you say, I want all of the information that you have about, or I want you to do up a spreadsheet with certain information. If it doesn't exist, the public body isn't required to actually generate a record for you. What you're entitled to see and get a copy of is records that already exist. So that's an important distinction, and sometimes people don't realize that. They think that FOI can give you a right to get a body to create a new record for you. Important point to note that you may be able to get the information outside of the FOI, and we would always encourage public bodies to make the information available outside of FOI. So sometimes just ask the body before you make your FOI request, ask them, can you have a copy of whatever it is you're looking for? And you may even find that it's on their website. It may be that you couldn't find it on the website, or they may agree to put it on their website, or they certainly may agree to give it to you. It's a quicker and easier route for everybody. And there are two sides to this. One we constantly encourage public bodies, as I mentioned earlier, to put the maximum information up on their websites and to make it available without it having to be FOI'd. But also we ask the public and people who are seeking information to engage as best they can with the public body and see, is it possible to get it without going through the formality of an FOI request. And I've mentioned that you can seek an internal review. So if you're unhappy with the outcome, that, in other words, you've been refused certain documents, or maybe you've been refused all of the documents or part of the documents, or maybe there are part of the documents redacted, in other words, parts of it are blacked out that you're not getting, you can seek a review of that decision by requesting from the body itself, the public body, an internal review. And it's the result of that internal review that may lead you to our office. If you're still unhappy with the outcome of the internal review, you can appeal to us. So next slide, please. There's no fee for making an FOI request, but the requester can be charged a search and retrieval fee by the FOI body. That sometimes happens if there's a lot of information, or the information is in a certain format and it's difficult to get. There is a fee for the internal review of €30, which I think is reduced to €10 if the person has a medical card. And similarly, there are fees for making an appeal to our office of €50. And again, that is reduced, I think, to €15 where the person has a medical card. So that's the situation there. We'll move to the next slide, please, Michael. There are certain records that are exempt, that in other words, you can't get. And it's important to point out that not just records, but there are certain scenarios and situations in the legislation which provide very specific exemptions. And if you receive a response from a public body with just a flat exemption saying, all of this information is personal information, that's not acceptable. They have to come back to you and tell you what records they have and tell you which records are exempt and why they're exempt. But there are these blanket exemptions as well, which are meetings of government. It's not possible to get the deliberations of the government when it's meeting in cabinet. Certain deliberations or functions and negotiations of FOI bodies won't actually have to be released under the legislation. If the information was given in confidence and it's proven that it's given in confidence, if information is commercially sensitive, or if it's the personal information of another person, then you won't actually get that information. So while you have a right of access to your own personal information, you don't have a right of access to personal information on other people. So we'll move. Our role then, as I say, hopefully people, and it's important to point out that a huge amount of information is actually released. I think it's only about 18% usually of FOIs are refused. Some are part refused. And I think we are up around 38,000 requests per year to FOI bodies. It's a lot. There's a lot of activity. It's been growing each year. So there's a lot of FOI requests. There's a lot of activity. There are a lot of responses. There are a lot of people who get the information that they seek. I think that's important, because if you think of 37,000 requests a year or 38,000 requests a year, and we receive 600 appeals in a year, so the vast majority of requests are actually responded to positively by public bodies, and only enough, but a smaller portion of them come to us, So we're independent of government, an important point. We make that decision. We're independent of the public body, we're independent of government, and we're also independent of the person who's seeking the information. And that's really important, because if we lose our independence, then we're not of any help to anybody. So it's very important for us to be able to stand in the middle and make an independent decision based on the facts and based on the documents and based on the legislation. And it's also important to point out that in making the decision, we seek the documents from the public body. So if a public body is saying the information is commercially sensitive, or if the public body is saying that it is the information of somebody else, another personal information, we're able to independently look at the information and decide that. Obviously, we won't then make it available if it's information that is genuinely exempt. We won't make it available. We will uphold the decision of the public body. But it's a substantial job, as you can imagine, to actually go through all of those records. And we're talking line by line, because it may be that 90% of a document could be released and is releasable under FOI, but there could be a small portion in there which refers to an individual, or that has maybe commercially sensitive information. So we review those. Our decisions are binding, so they're legally binding on both parties. So if we direct the public body to release the information, they've got to release the information. If either party, if the public body or the applicant is unhappy, or the appellant is unhappy, they can appeal the decisions to the High Court. So because they're binding decisions, legally binding decisions, we're very careful in them, and they're very detailed decisions, and should stress they're actually on our website. So people can go in to our website and see the decisions we've made. We publish all of them. We publish our annual reports, which sets out the overall landscape and the pictures in relation to FOI each year. And we publish kind of commentaries on decisions, and also we publish case studies. And the purpose of this really is to try and educate public bodies in relation to good behavior, bad behavior, and what is acceptable and what's not acceptable, and the exemptions they can apply, but also to give the public an understanding into the how we arrive at our decisions, and the kind of information that we are likely to release and the kind of information that we're not likely to direct the release of. You can move on, Michael, to the So the supports that are available, there's our website is there, www.oic.ie, and I mentioned that all the decisions are there. Also, there are some guidance notes. The decisions are anonymized, by the way. We don't identify the requesters. We also have some procedural manuals which can help people to understand our processes and follow our processes. In addition to the website, I'm conscious that the telephone number isn't there, so I will give it at this stage, Michael, and we might add it to the slides before you circulate them. But our telephone number is 639-5689, 639-5689. That's a 01 Dublin number. And you can email us at info@oic.ie. And I would say to you, if you're wondering whether you should or can make an appeal to us of a decision, contact us. We don't advise people as such, but we'll certainly provide you with the information, and hopefully enough information to help somebody to know whether they think they can make an appeal to us, or whether we can be of assistance. Separately, there is an FOI Central Policy Unit in the Department of, I still call it, I'm afraid, deeper, Department of Public Expenditure and Reform, but I know the National Development Plan is features in the title somewhere, but it's www.foi.gov.ie, and they are responsible for policy, and they are responsible for the legislation, and they also provide some useful guidance, and they particularly provide guidance to public bodies. I should say we do these kind of webinars for public bodies as well, and we probably drill down quite a bit into the exemptions and how they should apply them and how they shouldn't apply them, and case studies from ourselves. So we're really anxious to try and have good practice in this area and make sure that public bodies actually abide by the law, but not just the letter of the law. We want them to abide by the spirit of the law. And the purpose of this whole regime, as I said at the outset, really is to open up government, is to be transparent, is to allow people to understand what's happening or what's not happening, and also to allow people to understand what information a public body might hold on them, and how to get that amended or changed or removed if necessary. I think that might be the last of our slides.
So.
Yep.
Thanks. Thanks for
so
that,
as I say, we'd be very happy for the slides to be circulated to people, and also our contact details. And I would stress to people, Michael, that they should contact us if they're in doubt, and by telephone. I do make a point about the fact that it can be so hard nowadays to contact some public bodies by telephone, but we're quite happy to take calls and hopefully be of assistance to people.